My name is Bonita Chang. I'm one of the staff counsels at the Hawaii State Ethics Commission. And I was asked to do an overview of the ethics code, and I tailored it for boards and commission members. So some of the issues that you may encounter in your work as members of boards and commissions with DCCA, we'll try to cover some of the highlights of that points. But due to time constraints, I'm not sure that I'll be able to cover all the particular situations, but you can always feel free to contact us afterwards with your questions. Okay. So the State Ethics Commission is comprised of 5 members, and we have about 11 staff members at our commission. And our primary areas of responsibility include education, like trainings like today. We also provide guidance via phone is the main way that people call us, or email. We do more formal types of guidance as well. We also handle disclosures, including financial disclosures, gift disclosures, as well as lobbying disclosures. I won't be covering lobbying laws, that's a whole separate chapter, but we do handle lobbying disclosures. And then also we handle enforcement. Okay. The State Ethics Code is actually embodied in our state constitution under Article 14. So we're one of the, I think we were one of the first states that actually enacted a provision as part of our constitution, and that's how important it was. And it's now codified under Chapter 84. So who does the State Ethics Code apply to? It applies to state legislators, state employees, and members of state boards and commissions like yourselves. It does not apply to state court judges because they are subject to their own code of judicial conduct. But state judiciary employees, like their staff members, they are considered state employees and therefore subject to the state ethics code. So today I'm going to just hit a couple of the topics that you would tend to encounter or possibly encounter. There are a couple areas that I won't be covering today, but the main areas that I'll cover today are financial disclosures, conflicts of interest, gifts, fair treatment law, and post-employment. I won't be covering confidentiality, since that's pretty much straightforward. Don't use or disclose confidential information that you obtain in the course of your work as board of commission members. And also contracts laws, which is very specific. So those are 2 areas that I won't be covering today, but I encourage you, if you have an opportunity in the future, we do provide more extensive training as part of our more regular standard courses, and there's one coming up in October, and then we also do it throughout the year. We're also going to be launching online training, so if you want to have more in-depth training, you can always attend those things. But today is going to just hit the highlights. Okay, so for financial disclosures, who must file? State elected officials, state board and commission members who are non-advisory commissions, and state employees in certain positions. And the main purpose is to identify potential financial interests that may conflict with your state duties. And I think for most of the DCCA board members, you're a confidential filer, so it's all basically not publicly available. There are only 15 state boards that are public filers, which would be example like BLNR, Board of Regents, the larger boards. Okay, and then we launched about 2 years ago an e-filing system, and so I think the vast majority of people file electronically, and we're going to be doing further enhancements to the system. But if you ever have questions on how to file or you're unable to log into your account, you can always call our staff, and the staff members are always able to assist you and walk you through the process. Okay, so moving on to conflicts of interest. We're going to illustrate some of the provisions using these hypotheticals that I created. So looking at Carol, she's a member of the State Board of Examiners in Optometry, and the board is scheduled to hear a complaint against Volcano Eye Center. Carol's husband is an optometrist with Volcano Eye Center. Can Carol participate in this matter? Okay, how many of you say no? Okay, how many say that, well, I don't think there's an issue? Okay, your gut instinct is correct. She has a conflict, and it falls under 8414A, which is also known as the disqualification rule. And this rule generally says don't take official action directly affecting a business in which you have a financial interest. So in Carol's situation, it's her husband's employment interest that is affected. If she were to take an official action on her husband's employer, she may be tempted to go easy on them for fear of having him fired, right? So not to say that she would, but it just puts her into a split loyalty situation. And in other kind of situations, like say licensing, or where the husband's employer has a competitor, they could challenge that question and drag your board into a big mess. So for these situations, we always say she has a conflict and she has to recuse on that particular matter. Doesn't mean that she can't sit on the board, but just for that particular matter, she steps off the out of the meeting and doesn't take any official action. She best practice is to state on the minutes, I'm recusing myself for conflict. You don't have to go into like a full narrative, but just to state on the record, just so that it's documented, and then you can leave the room and then come back in when it's over. And then that way you have a paper trail in case anyone should challenge it. Okay, so when we look at financial interest, there are not just your employment types of interest, but ownership of a business, having outside employment, being a director or officer of a profit or nonprofit entity, like say a board member on a nonprofit organization that you volunteer with, owning property, debt, or you're a creditor, someone owes you money. So those are types of financial interests that are subject to the state ethics code. And in terms of whose financial interests we look at the employees, but we also consider the spouse as well as dependent children. Dependent children is defined as individuals that are claimed as dependents on your state or federal income tax form for tax purposes. So adult children would not be in that immediate circle. But as you'll see later on shortly in fair treatment law, it could come into play where there's an issue where if you're giving preferential treatment to an adult child, it could be construed as a fair treatment issue. Okay, and in terms of official action, what types of action you take, it's fairly broad. It's not just the decision-making itself, but it's also the review, the discussion, any type of discretionary authority that you take in your capacity as a board member. So that can be fairly broad. So let's look at John. Okay, John is a member of the Consumer Safety Board. The board has hired a consulting firm to develop a consumer survey on identity theft. The consulting firm is impressed by John's expertise on consumer safety issues and invites him to join the company's board of directors. Can John accept this position? How many says, yes, good opportunity, I don't want to give it up? How many says, no? Okay, you're correct. The conflict is he would be acquiring a new financial interest by joining that entity's board. And under 8414B, the general provision is don't acquire a new financial interest in a business if there is reason to believe you will be taking official action affecting that business. So in this case, he's already in an existing relationship with that entity, the consulting firm, and they're working with them on developing this consumer survey. So he's going to be working with them, and it could be, I don't know, contract extensions, approvals, change orders, who knows, right? And so that is already a vendor relationship. So he can't then join their board because then he's going to be conflicted out. And the notion is, the distinction that I always remember of the disqualification rule versus the new one. The disqualification rule is if you come into the state board with existing conflicts, then you recuse. But this one is don't go to the conflict. Don't create new conflict. Because we want you to serve for the public, and that's the first priority for the state. And don't go during your term creating new conflicts. Okay. Okay, so let's look at Shannon. She's a member of the Real Estate Licensing Board. She's also an attorney in private practice. The board has set a hearing on whether the license of a real estate broker should be revoked. The broker has asked Shannon to represent him at the hearing. If Shannon recuses herself as a board member, can she represent the broker? She's not wearing two hats. How many says no problem? How many says, that looks weird? Okay. That actually is prohibited under 8414D, representational conflicts. So the concept of that provision is basically don't assist or represent others for pay before your own agency or on a matter in which you have participated or will participate. So in this situation for Shannon, it's before her own board. So even though she's like, oh, well, pretend you don't see my hat as a board member, I'm just the attorney in this situation, you're still dealing with your colleagues, right? And so it's a little bit odd to then switch roles and go onto the other side of the table. So, and because it's, in this situation, her representation is presumably for pay, I guess, there are situations where you're not doing it for pay, but that gets a little bit closer to the margins, and it could raise fair treatment concerns as opposed to an actual conflict. I would just generally say don't engage in that type of representation, whether for pay or not, before your own board. It just gets too sticky, especially when you're dealing with a lot of your boards are licensing boards, right? You're regulating industries and other fields of area that affect consumers, right? So you want to be really staying on the right side. Okay, so as a sum up, conflicts of interest, which is really complicated, but if you remember anything, there's 3 general principles. Disqualify yourself if you have an existing conflict, don't create new conflicts, and don't represent or assist others before your own agency or on matters that you work on for pay. So those are just a quick overview of the conflicts, but conflicts is one of the probably more stickier areas. And so, I encourage you, if you find yourself in a situation that you're not sure, you can always call us and we'll walk through the facts because it's very fact specific. Okay. So moving on to gifts laws. Okay, gifts laws is under 8411, and generally the rule is don't accept or solicit any gift if it's reasonable to infer the gift is offered to influence or reward you for official action. So there are a broad range of gifts. So that would include food, gift cards, which are considered cash, concert shows or entertainment tickets, special event functions like golf, charity golf, and travel. So these are basically anything of value that you receive in your capacity as a board member. The factors that we usually apply to determine whether or not it's an improper gift would be, what is the relationship between you and the donor? That's one of the probably the more key factors. So if, let's say, it's a vendor relationship or it's a licensing or regulated entity situation, those are red flags. Or if you're a law enforcement situation, we usually say, we would recommend declining the gift because of the special relationship. The appearance from an objective person standing on the side is it could be construed as an attempt, basically a bribe. And so the other factor that we do look at, though, is what's the value of the gift. Even though the gift law has no dollar threshold, we do take into consideration the dollar value relative to the other factors. So, and the third factor, which is also very important, is what is the state purpose? Is the gift essentially a personal gift to you, a personal benefit, and has no real state purpose? Or is there a high state purpose? Like, for example, something that helps you do your job effectively and benefits the state and outweighs the other potential factors that could be construed, okay? So it's kind of like a balancing test. When we weigh all those factors, that's why, like conflicts, gifts law is very fact-specific as well. So let's take a look at some hypotheticals to illustrate how that all plays out. So Laura, she's a PUC commissioner. She's invited to play in a charity golf tournament that by an electric utility company that is regulated by the PUC. Okay. What's the relationship? regulated entity, right? The value is most likely high, probably in a couple $100 range, including swag and whatnot, right? State purpose, and don't say networking, right? Because if it was a true networking situation, do it in a business meeting, right? Not on the golf course, right? There is, for the most part, a benefit to her personally. It's a social, function, right? It's also benefiting a charity organization, and she shouldn't, as a regulator, she shouldn't be in that situation of accepting that kind of gift, because it could be easily construed that it would be an attempt to influence her in a decision by the regulated entity. So this was an example that actually the commission had taken enforcement action about, 5 years ago. We had 40 golf cases that was actually published involving high-level government officials that were awarding state contracts in the millions of dollars to entities that were regularly inviting them to charity golf tournaments. And it was like a regular practice. And so the top-level officials, their names got published as part of the resolution of the matters, and they ended up paying like several $1,000s fines. The lower-level employees had differing values of fines, but basically they enforcement action was taken in that situation. So in this situation, we would say no. Okay, so let's look at another gift example. Okay. As the chair of the State Pharmacy Board, Kim is invited to speak at a conference in Seattle. The National Health Organization that is hosting the conference offers to pay Kim's travel expenses. Okay? How many says yeah? There's a state purpose. How many says, no, I don't know. She's getting a free ride. No one ever pays for my travel, by the way. This is a situation where the vast majority of travel requests that we get, this is the type of situation that we would say, oh yes, okay, no problem, because it helps to subsidize your trip, because otherwise your board or agency would send you anyway, because plenty, say employees have to represent the state, going to these national conferences. It helps them do their work. There might be some sort of conference sponsor or think tank or foundation doesn't generally do business with the state. They want to encourage government officials to attend, so they will have a small pot of money available to help subsidize your travel. So those usually situations where the gift value may be very high because it's mainland travel, but the state purpose is so high that it outweighs any. The relationship is so minimal, that there's no concerns there, that the state purpose would outweigh the other two factors, right? The other kind of examples that we encounter that's not even a gift would be if the state agency is a member state of that entity. So sometimes like the AG is a member state and they have to send a representative to that meeting on a national basis. Their dues, Hawaii pays dues that covers that membership, and it includes travel. Those aren't even gifts. It's part and parcel of your membership. So those are completely different. But if you're not sure, we do have travel questionnaire forms on our website. You can fill it out and then call us up, and then we can walk through the analysis. And the vast majority, like I wouldn't say 99% of the travel requests that we get are all okay to accept, just report the gift. Okay. So to sum up the gift analysis, the first question is always, can you accept the gift? And then the second question is then, are you required to report it? So for the gift disclosures laws, it's a separate provision under 8411.5. You have to report if the value of the gift is more than $200 and the donor has interest that may be affected by your official action. So generally we say if it hits the over 200 level, then just report it. And the gifts reports are usually due June 30th. And we have electronic filing for that, and you can fill out the form online. Okay, any questions on gifts so far? Question?
In the previous example, when the officials took the golfing invitations, so is that a situation where the liability is not protected?
Yeah, just because you report doesn't mean that you're insulated. Yeah, so generally the office will review gift disclosures and kind of preview, say, are there any issues? It might prompt a routine follow-up question because maybe there's something there that's we didn't know about because it's just a form, right? So we'll probe a little bit more and ask for clarifying answers. But generally, if we recommend you call us before accepting if you're not too sure. Because there always is a what we call an attorney of the day. So we handle the hotline basically, and we rotate it. So each person every day is covering the phones, and we'll handle the questions. So generally, we try our best to get to your question right away. Unless it's a super busy day, then we'll call you the next day. So we try to respond, or via email. If you have a quick question, you can send it out, and then it gets assigned to the attorney of the day. Okay. Any other questions on gifts? Oh, okay, sorry. Let me repeat the question. So it was a question about financial disclosures, and if you acquire an interest after you submit your disclosure, do you need to file an updated disclosure, right? Generally, we don't expect you to constantly be updating your disclosures form. You can, because the electronic system now, it's easy because you can amend and it will grab your last filed information, and you can update it very easily. But generally for our office, for administration purposes, it's pretty much the once a year cycle. And then we catch you the next time around, right? The only time I would say call us if you're about to acquire something is if it creates a conflict where I say, oh, you know what, you shouldn't acquire that that interest. It might create issues or whatever, or more for guidance purposes as opposed for the disclosure. Because, people's lives throughout the year, you might have a lot of changes, and so we can't expect you to constantly be updating the form. Like, it's almost like, I don't want to equate it to tax forms, but it's kind of like, if you think cyclically, once you file your initial disclosure, then it's the May cycle for board members. Legislators are January, but usually I don't expect them to file every month when something changes or whatever. Because you could have say stock holdings or you sell property. It's just too much, right, to constantly change. So generally.
So I just, so that was just a yes or no question.
Yeah, so no, you don't have to update your form.
And then the only reason why is, in another library, because we're volunteers, I don't want to make work harder, make more work, but on the state end, in another entity, we do annually report disclosure, but if anything changes, we're supposed to report within a very short period of time. This is the university.
Right.
So I was just wondering, because usually state entities tend to be, despite the perception, tend to be fairly consistent with procurement and all the other things. So I just wanted to make sure that this was not the Ethics Commission's requirement. Just to be sure, because that's one less thing I have to think about.
Yeah, so we just send you that notice, for that May filing, and you just add an update from the year before, all that
and this
changes.
may be a little bit different, but I think in the context of speaking engagements, like say by this national organization, how would you want us to approach disclosures at that entity? Because, for example, even if, say, we're chair of a board, we're limited in the scope of what we can say on behalf of the board. And so can you touch on that just a little? It's a little bit different from what you're talking about, but it does deal with managing conflicts of interest.
Okay, I don't know if it's so much a conflict, but more of a fair treatment in terms of you don't want to be misusing your position, or using your position as a state board member in some other private capacity. So, or dragging your board into a matter that's not their official role. I guess it would be more of a fair treatment question.
So I think, so what you're talking about is real easy. We just put on the disclosure slide, right? That it's, we can just put on a disclosure slide that it's our opinions and not that of the entities with the privilege to serve.
Right.
But the example that's in the packet, like when you're invited by a national organization,
right,
and the context is that you are chair of your board,
right,
and you're being invited based on that premise,
right,
then the question I have is if you can clarify what is the scope of what you could say in that particular setting when you're invited by another organization.
Right.
Because of your role
Right.
as a board chair or member, what can you say on behalf of that entity? How should that be managed in terms of potential conflicts there?
Right. So if you're invited in your state capacity, right, either as a speaker or as an attendee, you're going on state time. So you're representing the board in that capacity. So you're, the reason why you're there is because you're a state official wearing that hat that moment, as opposed to just, paying for your own pocket and going to some private function or conference and it relates more to your side employment as opposed to your board role. Those are kind of like separated, right? It's always good to kind of, if you're a, I guess, well-known board member, it's always good to have that qualifying language just to kind of preface it. But if you're invited in that gift scenario for the travel, I would recommend that you check off with your agency or board, in terms of taking any official position, because usually going to those conferences because you're representing the state board on some, I don't know, it could be national rules, codes, whatever, right? So you want to make sure you're representing the state's position and not deviating from that. As additional reminder, when you go to those kind of things and you're inviting your state capacity, you should not accept honorarium. You can donate it to your agent because you're going on state time, right? So the honorarium would be considered, I'll cover it in the fair treatment section, but it's considered additional compensation because you're already going. So you would then, more so for state employees, they often get that, right? They're paid like a director of whatever. They'll go to the board to speak on some matter, and they're given an honorarium. They can donate the honorarium to their agency because it's basically compensation to the state. They just can't pocket it because otherwise that's like getting extra money, right, for going in your state capacity. Like I can't go to an ethics conference and get paid, extra for that. Okay, so I hope I addressed some of the issues, but again, if you have more specific questions, you can always call us after today's event. Okay, so I'm going to move on to fair treatment. So fair treatment, I touched on it, real briefly, but basically the general concept is fair treatment, being fair, not giving preferential treatment to benefit yourself or others. So the general rule is don't use your board position to benefit yourself or others. Don't use your position to do favors for friends or family, and don't abuse your authority. And in, the headline news, we've been hearing a lot of abuse of power, misuse of position, misuse of state resources. This is under fair treatment law, and it's generally under 8413, but there are specific provisions under the fair treatment law. Fair treatment law would also include using your state position to seek private work or contracts, right? So, hey, what kind of opportunities do you have? And you're negotiating as part with a vendor or someone that does business with your board to then parlay that into your private opportunities for yourselves. Additional double compensation, as I touched on, and then also financial transactions with subordinates, more so for supervisors in employee side, but basically, don't engage in substantial financial transactions like, say, selling your car or buying loans or whatever because of the imbalance of power. Also, another area of fair treatment is using or misusing state resources for private business purposes. So that would include profit or nonprofit entities. So that would be like fundraising, campaigning on state time, running businesses. We've seen the whole gamut of private business activities. And state resources would include state offices and facilities, state time and personnel, office equipment, state email system, and even, you'd be surprised with state equipment, like heavy equipment. So those are kind of like a quick overview of the fair treatment law. Any other questions on fair treatment? Okay. So the next area, the last area is post-employment. So this would be after you leave the board and your term is over, there is generally post-employment provisions and restrictions. It's under 8418, and the general concept is to prevent you from engaging in influence peddling or the revolving door effect of leaving state and going to private and using the influence that you have in the state board to benefit your post-board role. There's a 12-month cooling off period. So from the time you leave the board, let's say your term ends June 30th, then July 1st till the July 1st of the following year would be the 12-month cooling off period. And during that 12-month period, you cannot be paid to represent another person or business on matters before your board or agency, or matters in which you participated while sitting on your board. So that's basically, a 12-month period to just cool off, and then after the 12-month is run, you would then be free to appear before your board on whatever matters. Of course, the confidentiality rule, there's a confidentiality provision under the post-employment law, and that's forever. There's no 12-month period. If you obtain confidential information during the course and scope of your work as a board member, you cannot use and disclose that ever. So just because the 12-month is up, you can't be reviewing that kind of information, because that is confidential. And confidential means information that is privileged by law, or information that is not publicly disclosed. And it's not necessarily like procedures, but more like deliberation, internal decision-making, the reasonings, things that you would not disclose subject to a FOIA or a UIPA request. Okay. There are also a number of exceptions for post-employment. The board could always bring you back and let's say hire you as a consultant to help them for state purposes, or usually like say, we've seen it more on the employment side, where the employee is brought back on an 89-day hire to finish up their work, to train the successor. Those are usually the post-employment exceptions. Board members, I don't know what scenario that might come into play, but again, if you have post-employment questions and you're not sure, feel free to call us. Any questions on post-employment? Okay, so quickly going over penalties. The fines are up to $1,000 per violation. If we go through a full hearing and we find that you violated the ethics code, we would then refer that matter to your employing agency through the governor for further disciplinary action, whether it be, I don't know how it plays out in the board situation, but that would be within the purview of your agency. Recovery of gifts or profits would be handled by the Attorney General, and contracts or actions can be voidable. As I mentioned, if you remember anything, it's that you can always ask us for questions and for guidance via telephone, email, staff letters, or we can provide guidance in the form of either verbally, through emails, a little more formal staff letters if you have more of a complicated situation, and in the more formal situation would be the advisory opinion. Usually those are reserved for questions of unusual ethics situation that the commission hasn't encountered before, or situations where you just really want the advisory opinion. We have issued several, just even this last couple months, dealing with situations that were fairly unusual, that the individual wanted a formal advisory opinion. It's a little bit, goes through a different cycle, and there's a timing period to that, but that is an option available to you. But the vast majority of questions that we get are phone or email. So feel free to always call us, and advice is confidential. Okay, and then lastly, the contact information is available in your handout, so feel free to contact us. And if you have any questions, I think we're gonna, I don't know if we're gonna have a break or not, but you can always call our office later today or next week at any time. Thank you very much.